Welcome to Witchdraft. This is Jason Mark Anderman. Today we're going to dive into the world of employment contracts. The main things you're thinking about if you're an employer when you sign someone up to be your new employee, when you hire them, is to really protect yourself on certain key issues that tend to come up over and over again with employees. Those issues pretty much tend to focus in on confidentiality, non-solicitation, non-competition, and intellectual property. So let's take a look at this here. First and foremost, you want to make sure you make it clear what's the role that this particular employee is going to be employed in. And in this example, we say to create software applications as an employee of and as directed by Jason LLC. Kind of the reason you list this is when you disclose information, your confidential information, to this new employee, you want to make sure that they protect it. And it's a good idea to specify the role because you only want to give out your confidential information to them within the course of their employment as necessary for them to do their work. And you don't want them to be sharing information to all kinds of people without some kind of restriction relevant to what they're doing. So that's kind of why that's important for confidentiality issues. The big thing with confidentiality, though, basically, is it's your exclusive property, your information, and you don't want it getting out. So basically, you want to say to them, don't disclose the information. There tend to be some normal exceptions to those things that are already in the public domain or independently developed or rightfully received from a third-party source. But otherwise, pretty much you're just saying to them, hey, I want you to respect non-disclosure and not give this to any third party that might be out there and protect it. You might say, hey, you can give it to some third parties, agents and subcontractors, for instance, but only those ones that I, as the company, specifically designate. And that's kind of what's important there with confidentiality. Another big thing that comes up a lot in these kinds of agreements is non-competition. And basically what you're worried about there is this employee is going to take off and basically start competing with you and really use their employment with you to have a big leg up and take your customers or end up as a solid competitor. You can't really stop this forever. People have to earn a living, and the law really recognizes that. What you want to kind of nail down here to make really crystal clear is exactly what they can't do to compete with you. So for instance, in this case, we might say online document assembly software, which is what Witchdraft does for a living. And you also want a geographic restriction. Usually you might say United States of America, might be smaller than that, might be bigger than that. And the other big thing you want to make sure is how long it lasts. Generally, these things don't last more than a year. But it does vary from state to state on these kinds of descriptions and geographic areas and time limits. So you definitely want to talk to a lawyer in your area who's an expert in employment law, and they'll help you out with that. Another big thing you're probably going to care a lot about is non-solicitation. And basically, you don't want them to be going after your existing employees and poaching them and taking them to the employee's new business, whether the employee starts the business themselves or they go get a job with a competitor of yours and then steal all your best performers. Now, obviously, you can't prevent this forever, but it's typically normal to be able to say, hey, for 1 year, you're not going to go off and take my best people. And that's pretty much the kinds of issues that come up with non-solicitation. The last thing you're going to really care about is any kind of work that gets done, developments by this new employee that contribute to the company. From time to time, what you're going to find out is they'll bring stuff to the table that they developed previously. Might have been on their own time that they own, might have been owned by their previous employer. You really want them to disclose all of that up front, and you really want to make sure that you get clarity around, do we have clearance from this other employer to use this stuff? If not, then we can't use it. If this employee owns it, who owns it when the employee leaves the company? Is the employee going to sign all intellectual property rights in it to us, or are they going to give us a permanent license? So you really kind of want to hone in on these employee developments, this work that gets done, whether it's software code, data, databases, anything. Well, those are the key issues that come up over and over again in employment agreements. Hope that's helpful for you. Thanks for using Witchdraft.